Okay, hello everybody and welcome to our Community Legal Education webinar for this morning. Our topic is living with domestic and family violence. This is a second webinar in the series that Jason Garrick, who is our presenter today, will be sharing with us. So thanks Jason for being here. Jason's our acting senior lawyer of our Counselling Notes Protect Service and he'll be presenting today. My name is Linda Richards. I'm the Community Legal Education Coordinator here, and we've purposely tied our topic in today with the 16 days of activism, so that's a running theme throughout the presentation today. So I'll just hand over to Jason. There's a few facts there about 16 days of activism that I'm sure many of you are familiar with, but we've certainly been acknowledging all the different campaign and messaging about this important issue. But I'll pass over to Jason to do our acknowledgement of country as we begin.
Thank you. I'd like to acknowledge the traditional custodians of the land on which we meet today, the Jagera and the Turrbal people, and I'd like to pay my respects to the elders past, present and emerging. I'd also like to acknowledge the traditional custodians on the land in which I grew up on, the Barada people of Middlemount, the Kungalu of Blackwater and the Darrumbal people of Rockhampton.
Thank you, Jason. And just a reminder that today's webinar is for community legal education purposes. If today's webinar does raise some issues for you or for the people that you're supporting, we'll certainly include all our contact information. So if anyone needs some advice or extra information, please be in contact with us through our 1300 number. Today's webinar, there's just a few little housekeeping things that we usually go through. The webinar is being recorded, and that means that we can then load it on YouTube for you to view later, or if some of your staff haven't seen or been able to make it today, you could watch it at a later time. It's the Legal Aid Queensland YouTube channel, and it's on, the link is from our webpage, but it's also from our Information for Community Workers page on the website. We caption all those videos as well. Technical help is available on 1800 136 402 if you're having any trouble seeing us or hearing us. That's the number to call. Just a reminder also, most of you I'm sure are familiar with the webinar, GoToWebinar technology, but if you do have a question for us, please type that in the question box that you'll see on the screen here, and we'll address those towards the end of the presentation. And there is also a handout of the slides that we're going through today. So we'll start with a poll. This just helps us get a sense of who's linked in today and who our audience is. So I'll just launch that poll now. The question is, which region do you work in? Do you work in South East Queensland, Far North Queensland, Regional Queensland, or outside of Queensland? So we'll just open that poll now and look for those responses. Thanks. You can see some responses coming in. Okay, we might close that now. Thank you very much, everyone. We'll share those results with you. It looks like we've got 49% of people from South East Queensland, 22% from Far North Queensland. So that's fantastic to be reaching people as far north in our state. 22% from Regional Queensland and 7% outside of Queensland. So I know whenever we get to the outside of Queensland people, we do need to address the legislation and whether it's state-based or Commonwealth. So
yeah, absolutely. So for those people who are outside of Queensland, our legislation is state-based for domestic violence. This is not a family law seminar. It's about domestic violence and family violence and how we deal with it in the state courts in Queensland. That being said, it's always good to know what other states are doing and how we're dealing with family violence, and sometimes it can prompt us to think a little bit more laterally and differently about what we do and how we do it in our daily practice.
Thank you, Jason, and thanks everyone for your responses to that poll. I'll now hand over to Jason to talk about what we'll be covering today. Yeah. And I'll be popping in and out of the webinar as we have polls and at question time. So thanks, Jason. I'll hand over to you.
Thanks. All right, so today we're going to go over the legislation's purpose, its principles and objectives. It's important that we understand what the law is trying to do and how it's trying, and what problems that the law has been designed to address. We're going to talk about the elements required to obtain a protection order. We're going to talk about what orders can be made. So that's the nitty-gritty, that's the detail. You know, what is an order? What does an order say? What can it prevent people doing? I also want to talk about new aspects of the law. There's some good case law that's come out in 2018 that I'd like to address. And I'd also like to briefly talk and make reference to everyone about the Counselling Notes Protect Service, as the legislation that was introduced last year does apply to domestic violence relating to sexual assault. And I'd like to just acknowledge that service and what we're trying to do, because it may affect practitioners, whether you be a lawyer, whether you be a social worker, or work in the DV support space. And then finally, I'd like to talk about the resources and stakeholders that can help you navigate a client through the legal system. Right, so the purpose of the Domestic and Family Violence Protection Act is for the protection of a person against violence committed or threatened by someone else, if a relevant relationship exists between the persons. So it's about protection for a person. I should say that the purpose of the legislation is about maximising the objects of the Act, is about maximising the safety and protection and well-being of a person living with violence. It's about the prevention and reduction of domestic violence, not just for a person who is experiencing the violence directly, but also of children and other vulnerable people. Importantly, the fourth point that I really want to draw out of Section 3 is that it's actually about promoting accountability of perpetrators as well. Some people do have a difficulty with that word perpetrator, and I do acknowledge that, because that can stem into those feelings of blame, which may actually stop a person seeking help to address their behaviours and changing their behaviours in how they engage with people around them and how they use violence. But that's what the legislation says, and it's about making people accountable for their actions and how they treat their family and their partners. Section 4 of the Act. Sections 3 and 4 of the Act are actually quite important. I'm going to explain that a bit later why. But the principles of Section 4 is that the Act must promote the safety, protection and well-being of people affected by domestic violence, and that safety and protection must be paramount. We should also identify that people who live with violence should be treated with respect, and perpetrators, again, should be held accountable. And we also, in the legislation, acknowledge there are certain people in our community who are vulnerable to violence. Women, we are in the 16 days of activism. We are talking about gender-based violence. Women experience family violence at a rate far higher than men. Children are vulnerable to family violence. People who are First Nations people, again, statistically, are also vulnerable, as with people who live with disabilities, a culturally diverse or have a culturally diverse background. I'd also like to acknowledge that if you are a person of the LGBTIQA community, you are also identified as a vulnerable minority, of which violence affects a significant proportion of that community. And we'll talk about some emerging issues in the LGBTIQA space a little bit later. And finally, I will say that this response and this legislation is about acknowledging that a civil response, in that civil orders which promote appropriate behaviours between two people, is actually about working with a criminal response as well. There are criminal consequences of breaching a civil protection order. We're about to run a poll again, and this is so that I can understand where you're all coming from. So if you can indicate once we open it where you might work. Now, if you are other, if you could throw in, if you're a lawyer, into other, that might help me understand how much legalese I might avoid using during this presentation.
Oh, it's a few there. Quite a few.
Yep.
Thanks, everyone.
Okay. So quite a few community support services.
Okay, collecting those responses. Okay, thank you, everyone. We'll close that poll now.
Okay.
And we can share those results with you.
Mm-hmm.
Did you want to go through?
Yeah. So we've got 9% of DV support services. We've got 50% community support services. We've got 2% men's support services, and we've got 39% other. So I'm going to assume that that is lawyers, as I've said. So that gives me a clear indication as to what information I should be sharing with you today.
Thanks, everyone. Go back to our slide. Oh, we've got another poll.
Yeah, one more.
Yeah. Okay, and once again, this gives us, as Jason said, more information about who your clients are, and some of the, Jason will be tailoring some of the information and material related to your client group. So we'll launch that one.
Yeah.
Who are your clients? People from culturally and ethnically diverse backgrounds, LGBTIQ community, Aboriginal and Torres Strait Islander people, elderly, women, men, and I'm sure there's others there too.
Okay.
Okay, so close that.
So we're looking at 66% women, called background sitting at about 24%, 3% LGBTIQ, 3% elderly, and 3% men.
Great. Thanks everyone for your participation in those polls. It's really helpful. Okay, back to Jason.
Okay, so when we decide to, when you decide to assist someone in obtaining a protection order, the court must establish three things. They must establish parties are in what we call a relevant relationship. There must be acts of domestic violence, and an order must be necessary or desirable. Okay, that's a big important distinction. It's not necessary and desirable, it's or desirable in the circumstances between the parties in which an order is being considered to be made. Relevant relationship. We're talking intimate personal relationships of all forms, family relationships, and informal care relationships. We're also going to talk about what is domestic violence. Now, if you're attending this seminar, I'm assuming, well, by the polls that you actually understand what domestic violence is. It's very important that we're familiar with the definitions of the legislation when we're supporting people. These are the, when you're helping someone, whether you be filling out the application for a protection order as a lawyer or as a social worker, assisting them tell their story, using these definitions as headings can really help your clients tell their story. Or using bold, it's, you know, there was a physical act, there was a sexually abusive act, there was an emotionally abusive act. You know, things like not having someone's access to a debit card is an act of economic abuse. These are behaviours which all control and dominate and causes fear in people. Okay, so we've included some simple examples there. The legislation actually provides for some really good examples, and I'd really suggest that you go and have a look at the legislation in how you may phrase or draft an application. Children are exposed to domestic violence, and I want to be very clear about this. A child is exposed to domestic violence if the child sees or hears or otherwise experiences the effects of domestic violence. We're talking, we often hear people's stories saying that the kids weren't there, they're in the other room, they were at the backyard. They hear these things. We know this. This is what the social science tells us. You know, when they see mum or dad upset and they come and comfort their mum or dad, where they see someone bruised or injured, where they help mum or dad or maybe nana pick up damage that's occurred, pick up the damage and pick up the pieces of broken property, holes in walls, seeing those things. And it's important to also acknowledge that children experience the financial stress caused by economic abuse. As much as people think that they're shielded, and it's not really, economic abuse is something that we really need to do a lot more work to destigmatise. It absolutely exists, and that's something that we need to have a very real conversation about. So if you are assisting someone and there is children of a relationship, the children are much more likely to be exposed to DV just by being in the household. I do want to talk about the definition of emotional abuse. We can all talk about physical and sexual abuse. We should know what those acts are. There are some really good examples that I've included here about emotional abuse, which is intimidatory, which is tormenting, which is harassing, which is offensive. We're talking about withholding medication. That's a horrible theme that's coming out of our elder abuse cases at the moment. Withholding medication, failing to pick up medication, failing to let them go and get their medication from their local pharmacy. We're talking about preventing a person's contact with their friends and family, outing a person's sexual orientation or HIV status, repeated text messages, emails and social networking, repeated derogatory taunts. Often the repeated derogatory taunts that we see are also on social media. Social media is something that is really helpful when you're prosecuting cases of domestic violence because it's there. If you are assisting a person with filling out their application or getting their evidence together, have a very real conversation with them about what's on their social media and making sure that they think about the way that they use social media as well, because it's very simple to go onto Twitter or Facebook or Instagram and blow off steam, but it can also mean that your client, who may be a person most in need of protection, finds themselves subject to a cross-application as well. Economic abuse, again, this is something which is coercive, deceptive, controlling, and is denying a person's financial autonomy or causing a person to fail to meet their reasonable living expenses. These three examples are the most prominent ones that we see. Social security payments, carers payments, a common thing that we see in elder abuse or people who are in an informal care relationship. That's what we see often. Their carers payments going to someone else, which means their pension is affected as well. Causing or coercing a person to sign documents they don't want to, going guarantor for businesses, all of those kinds of things, and preventing a person from seeking employment. Now, this is the third point that we're going to be talking about today, around what the elements are. It's the necessary and desirable. So the court must be satisfied that the protection order is necessary or desirable to protect the aggrieved from domestic violence. We talked about Section 4 earlier and Section 3 earlier. The objects and principles of the Act are core to making an argument that a person should have a protection order. When you think about necessary or desirable, for those people who aren't lawyers, and actually it applies to both, it's about whether the court should, and what are the risk factors, what are the concerns, why is it in everyone's best interests that an order be made. The other aspect of the necessary and desirable consideration is whether an intervention order has been previously made and whether or not that respondent has complied with that order. Previous behaviour is an indicator of future behaviour. Failing to address behaviours which are domestic violence are going to go against your client if they're a respondent. Alternatively, it will go towards any kind of reduction in terms, or particularly, removing an order if they have gone and done a men's behaviour change program or a domestic violence behaviour change program. The case law talks about a 3-stage risk assessment. I've started to talk about risk because that's part of my everyday language as a duty lawyer and as a person practicing in this area. There is a 3-stage risk assessment, which is well established by the case of AJS and KLB in the Queensland District Court. For those lawyers in the room, please make sure that you're very familiar with this case. It's very important, as it's often referred to. We must assess the risk of future domestic violence in the absence of an order. It has to be more than a possibility or speculation. We must assess the need to protect, such as where they live and work and have opportunities to interact and communicate with others. We must assess whether it is necessary and desirable by reference to the objects and principles. Sections 3 and 4 of the Act. That's why we took some time today, because it is absolutely paramount that we think about those things. Just some notes about this case. Want to be very clear with everyone who's here. Domestic violence is very, very serious, and seriousness of allegations and credibility of threat will always be considered relevant when we're talking about risk, and that's because of Brigginshaw and Brigginshaw. But the big thing that I want to emphasise, because I hear a lot of this working in the community, is that, well, I've got a temporary order and there's been no issue since the temporary order's been in place. Well, it should be complied with because it's an order of the court. Just because you're having good behaviour during the existence of a temporary protection order, it's not an indication that there's no risk of future domestic violence, because it involves an element of self-interest. That's, again, well-established case law. The other thing that I want people to think about, this is one of my favourite cases that I use to argue about nature and frequency of violence. And if you want to talk about harassment, then I could have a full 40-minute session on what harassment is. Go and have a look at this case, and it talks about what harassment is in the eyes of the court. Now, if you're supporting your client in making an application, you need to think about the evidence. The unfortunate nature of domestic violence and the closed-door nature of domestic violence is that we don't always see what's happening. It's only between two people sometimes. And that means that evidence can be really hard to find, to understand, to locate. So the evidence rules don't bind the court. It informs the court. Obviously, we are a court, we are an adversarial system. However, it's not bound by the rules of evidence or practice or procedure applying to other courts of record. It can inform itself in any way it considers appropriate. If your client is at court and you're supporting them at court and they are receiving text messages from the respondent, make sure that your client feels empowered to actually tell the judge, or the magistrate, I've been receiving text messages while I've been outside and this is what they are. We can actually apply to the court to have the ordinary rules of evidence dispensed with, Section 145 of the Act. I make submissions every single week on that issue alone as duty lawyer and say, I want to hand this up, I want to consider this. Your Honour, can you please have a look at the phone? These are things that the court must inform itself may inform itself in any way that it considers appropriate. Receiving abusive text messages while at court is an absolute appropriate way of dispensing with the ordinary rules of evidence, because it's demonstrating to the court the risk factors that we need to consider, and whether or not a temporary order should be made becomes a lot more clearer for a magistrate, particularly where a respondent may not have been served, or where he or she has not turned up to answer to the application. Now, I do note that a temporary protection order only needs to be supported by the evidence that the court considers sufficient and appropriate, having regard to the temporary nature of the order. Oh, sorry, I didn't mean to do that. We'll go last viewed. Before we go any further, it's important to note that with temporary protection orders, if a person is not there, that means that if the respondent is not there, it means that an order can be made ex parte. If an order is being made in the absence of a respondent on a temporary basis, because they're not served, the court must consider the three prongs of making an order, which is there a relevant relationship? Are there acts of domestic violence? Is it necessary and desirable to make an order, necessary or desirable to make an order for the protection of an aggrieved person? So that's just a practice note. Making protection orders. So when can a court make a protection order? Well, other than going to a hearing in a civil proceeding, a court can also make a protection order when it convicts a person of an offence involving domestic violence. So any criminal lawyers or practitioners who may be listening, or any domestic violence advocates who are working with survivors of family violence or victims of family violence, the court can make a final order when they're finalising the criminal aspects of a domestic violence offence. Okay, really important to know. Also, if your clients are in child protection proceedings, the court can, in fact, make those orders then as well. So it's important to remember that if a protection order can be made in proceedings outside of a DV list. Okay. Key practice point for support people, lawyers, anyone who works in this space. If your client tells you that it has been a breach and gives you details of the breach, it's important to report it to the police. It is so important. Now, quick poll.
Do we want this one, Jason? Or is it not?
I'm happy to keep going.
Keep going. Yeah, that's okay. Yeah.
Because I'm just conscious of the time.
There, and we would have time for questions.
Yeah. So, you know, protection orders can be made in three different forms: ex parte temporary orders, temporary orders at any stage of the matter, and on a final basis. Keeping in mind that orders can be made, and at the moment we're hearing in Southeast Queensland comments from the bench around when they make a temporary protection order, they do consider what's appropriate given that it is a temporary order. And that means that if they think that it might promote safety on a temporary basis, there might be an extra order or two that a person might not have asked for because of their assessment of risk and a person failing to attend a court proceeding. So we've talked about this particular issue of when a temporary order can be made. This slide is for your take home so that you can actually go back and reflect on that. Two key points of when a TPO can be made: a relevant relationship and acts of domestic violence. Okay. Now, ex parte basis, that's the only time when the court must consider the necessary or desirable test. Okay. If you're assisting a person with an application, please outline the urgency and concerns for safety of an aggrieved person in their material. Final orders. So the three elements need to be satisfied. Okay. Orders will be made final, whether it be an application for a protection order or an application to vary a protection order. Either way, they must consider that all three elements of the Act are satisfied. Now, I've just got some pointers here. If a respondent to an application for a protection order fails to attend court after being served, final orders can be made in their absence. I say can be. The correct word should be will be made, but sometimes magistrates give people a second chance. That's a decreasing phenomenon because the lists are getting bigger and bigger and bigger and bigger, particularly in the dedicated courts in the Southeast Queensland region, but also I do know Townsville as well is on the specialist court model. Also, if a party does not comply with hearing directions to file and serve affidavits, an application can be dismissed or finalised without further extensions of time. Now, that has been interpreted differently in the last 12 months with different case law around what's reasonable or not. To save face, just comply with hearing directions. If you can't comply with hearing directions to file and serve an affidavit, particularly as a practitioner, I would strongly recommend you writing to the court, asking for a further mention, and providing a letter to the court around that you're seeking an extension of time, and provide the reasons as to why an extension of time needs to be sought. Not being able to meet your lawyer's costs is not going to be a reason that the court necessarily accepts. So it might be about educating your clients as well into how to best self-represent them to a point, and going from there. Now, making final protection orders. Remember sections 3 and 4, okay? Because it's all about the objects and principles. So a court can make orders if the respondent consents to an order, if a relevant relationship exists and they decide to consent on a without admissions basis, there is no finding of fact. So it's important to note for those people who also practice in the family law space that a consent without admission order does not impede their family law proceedings, and no protection order will actually stop a person from being able to seek that their children's best interests are met through Federal Circuit Court of Australia or Family Court of Australia proceedings. Now, I will note, and this is a very rare thing, that the discretion of a court can be that they won't accept consent if it considers it poses a risk to an aggrieved or named persons. Okay, the court can make orders if the matter proceeds to a hearing and on the balance of probabilities that those 3 elements are met. I just want to be very, very clear with everyone here that there are options right up to the final proceeding, the final hearing, and please make sure that you talk with your clients, whether they be aggrieved or respondents, about their options, and particularly that without admissions clause. Applying to vary a protection order. Okay, if a protection order is in place, a party can at any time apply to vary the order to add or remove conditions. However, when we go back to consider when a court can make a final protection order, they must still consider those 3 elements. When a final order is made, particularly in circumstances where the police have applied for a protection order on behalf of an aggrieved person, we often see people back in court the next day or the next week saying we're still in love, we want to continue our relationship, and the police are interfering with our right to have a relationship and our right to love. The police have obligations underneath the Domestic and Family Violence Act. They also have obligations pursuant to the Police Powers and Responsibilities Act to keep people safe. And that's a conversation that often we need to have with clients. And it's about saying to clients, love is not an effective risk management tool because it doesn't address the behaviour. Love doesn't address the behaviour. But certain things can. So if you're in a situation where your clients are wanting to continue a relationship, they've got kids, they're wanting to improve their family functioning, that's why we refer them on to Relationships Australia, why we refer them on to support services, why we refer them on to counselling, because it can only improve the family functioning where people get the appropriate support in place. And I know I'll be preaching to the converted who do work in our community space, and I do acknowledge the work that you do because it does make a huge difference once people have received that information and understand that there is a whole community of people ready to help people who live with family violence. Okay, again, if you're applying to vary a protection order, it's not just about reducing conditions, it's about increasing conditions as well. So sometimes we'll see people, they'll come into court, they'll have that first court date, everyone walks away with a mandatory term order, and then the behaviour escalates. it's important to advocate with your clients and to educate your clients that going to the police isn't actually a bad thing. You do need to report breaches because it doesn't always trigger a variation. And if you are supporting them from a community workspace or a social workspace, please don't be afraid to contact the DBLO with the Queensland Police Service and actually have a conversation around what's happening for the client and whether or not they're seeking to vary it themselves, particularly if there's a criminal proceeding which comes up, before bringing your own application to vary. And the reason for that is that sometimes it's best that a client, that the police run that variation application, because it means that your client's not going to be in charge of running their own proceeding. So sometimes it's about advocating to the police why you're supporting this client to reporting that breach and the power in reporting a breach. We've talked about all of those considerations. The legislation says must. That means must. The court must consider the initial application and any findings of the court and any compliance with an intervention order. It must consider past compliance or non-compliance with an intervention order. It must consider whether safety, protection or wellbeing is affected. It must consider the wishes of an aggrieved person and whether or not there is duress or current contact between the two parties. Current contact is something that we do see where people are in jail and they want to vary the order so that they can have contact with the respondent. The aggrieved and respondent can be in contact because they're safe in jail. Be very cautious about that, and you need to be cautious about that because your clients are in a cycle of violence. If they are having ongoing contact with a person who has been violent towards them, it's possible that just because it's safe or it feels physically safe because you know that he can't do or she can't do anything to their partner while they're in jail, emotional abuse still continues, that manipulation still continues, and that can have dramatic impacts on a person's life who needs protection. It can affect their child safety proceedings. It can affect all of those issues. So just be very careful about applying for a variation and considering all of those things. When you do consider applying for a variation, sit down with this slide and think, well, what must the court consider? And what is my client trying to say? Conditions. So a court can make a whole heap of different conditions, and that can also be tailor-made conditions as well. The mandatory condition that is a feature of every single order will be that a person must be of good behaviour towards another person and not commit acts of domestic violence against that aggrieved person. The court can consider making prohibitions on contact, following, approaching, returning to a person's home, and also make orders with respect to recovering personal property or not recovering personal property, depending on what the cycle and what the facts and circumstances are. There can be restrictions on social media, naming children, unborn children, relatives and other persons who may be exposed to domestic violence. I will say that the section relating to unborn children is not the same as naming children. Off the top of my head, I'm pretty sure it's somewhere in the, I think it's 63 or 64 of the Act, which talks about unborn children. It is a separate area altogether. Find the legislation that key if you need to make the submission, and the order reads something like being satisfied that the aggrieved person is pregnant, that the unborn child be protected from being exposed to domestic violence. Okay, so don't let that clause throw you. Okay, please note, contact by a lawyer is not prohibited when there is an order in place. Now, what the legislation and the Not Now, Not Ever report wanted to do was to expand the powers of the court to consider what orders to be made. Just because an application says we want good behaviour between person A, person B, who are in a couple's relationship, the court can pick up that application and say, well, you haven't asked for this order, this order, this order, this order. But in making an order, the court must consider whether it's necessary and desirable to make further conditions, whether or not it's been asked for, to protect a person from domestic violence, to protect a named person from associated domestic violence. And the third point, which is quite important, is whether or not there is a child or children from a relationship, and whether or not they're at risk from being exposed to domestic violence. As an officer of the court, I would strongly suggest that any person who is an officer of the court and a lawyer, they should absolutely be highlighting to the court and providing the relevant information to the court about the children's names as well, making sure that the record is correct. Ouster orders, this can be a really difficult conversation for people. Ousting someone from a property can cause an aggrieved person further financial harm. If there are issues with your clients with rent and with property issues, please don't hesitate to refer them onto Q-Stars or alternatively onto Legal Aid Queensland. There is a whole lot of support that can be given to people in those circumstances. So ouster orders should always be sought, because the court must consider the safety and stability for children. It must consider the minimising disruption for an aggrieved person, retaining continuity and social connections for an aggrieved person and children, children of a relationship. It's important that those children maintain their childcare arrangements and training arrangements. And the final thing that the court must consider is the accommodation needs of a respondent. So if someone has nowhere to go, it's not something that the court lightly considers. It's not something that the court will say, well, you're a perpetrator of violence, and I find that on a temporary basis that I need to oust you from the property. That's not something that the court lightly considers. There aren't a lot of shelters for men, and that's something that we do need to accept as part of our practice in this space, is that there aren't a lot of options for men who get ousted. And similarly, with people in LGBTIQA relationships, where they're in a same-sex female relationship and they've been ousted, that can be very confronting as well, because the narrative can be very different, because they're a female who is considered to be a perpetrator of violence, and there is a whole lot of stigma associated with that. So this is something that we do need to be very respectful in how we ask for ouster orders, and when the court and what the court considers. The court will always provide for a respondent to return to collect essential items in the company of the police officer, and that's toothbrush, toothpaste, clothes. That's not the fridge. Always make sure your clients are aware of that.
About 15 minutes.
Too easy. Conditions, naming children. We've talked about this already. The court can request, the important thing that I will say about this is often we have a stoush in court about whether or not the children are exposed to domestic violence. The court can request information available at the time from a child protection authority who must comply if the respondent can test naming of the children under Section 55. Be aware of this provision and always consider it when you're representing an aggrieved or respondent in these types of proceedings. Altering parenting orders, I'll put it pretty simple. If a magistrate makes an alteration to a parenting order, seek legal advice. This is a complex area of law where our two areas of law intersect. They can do it. it's a power that they rarely use, or we rarely see it in southeast Queensland in our courts, but it is there. Intervention orders, that's something that has been changed from voluntary intervention orders to intervention orders. That was changed in the last 12 months. That's something to consider moving forward. Again, get in contact with Relationships Australia and Care and any other support services around finding out what intervention order programs are in your region. It's important to know what the wait times are. Durations of orders, pretty simple, 5 years, unless the court gives reasons, and they need to be pretty compelling reasons why it's less than 5 years. Okay. Yeah, 5 years, reasons for doing so. This is important for everyone who talked about working with culturally and linguistically diverse communities. The court has an obligation to ensure that both parties understand the proceedings and consequences. If you are supporting someone who is called, there is a practice direction that requires the court to have an interpreter there where it's appropriate. Okay, advocate for that. Do not be afraid to ask those questions. Do not be afraid to write to the court before a court proceeding and say, my client is requires a Burundi interpreter. She requires a Malaysian interpreter, Tagalog interpreter. Do not be afraid to ask the question. The court has a practice direction from the chief around making sure people understand what the orders are. New developments in case law. Now, ECW and ECW. This is a case where some of the courts in southeast Queensland are interpreting that they're more or less saying that, well, the court has to vary, well, to vary an order, the variation has to be applied in writing. On review of the case, I actually don't think that that's what the case says. I actually think what the court is saying is that the court must hear and determine an application in its entirety. It doesn't have the power to dismiss. Okay. Now, my words have disappeared, so I'm not sure what I've done wrong. I'm not great with PowerPoint. But what that second point should be saying is that a court should provide a party the opportunity to pursue their case. Okay. That's exactly what it should be. They're allowed to proceed. If their case is frivolous and vexatious, then that's what you should be saying. You know, it's a procedural fairness point that ECW and ECW is what I read the case to be saying, and certainly my colleagues here at Legal Aid seem to be understanding this course is saying that, well, the court can't just dismiss an application because on the face of it, it is frivolous or vexatious. It needs to go to a hearing to consider the case in its entirety, and this case involved an application to vary. So in the conversation of new case law, there seems to be a conversation around the imperative. It's the court's prerogative and a person's prerogative as an applicant or a respondent to making an application. And I'm talking about cross applications here, that they have their case heard. There are risks and there are costs implications of that, and cost orders can be made. BAK and Gallagher and another case, which, and this is why it's important to see ECW and ECW in line with BAK, is that an awarding of costs is confined to section 157 and applied to a proceeding at first instance. Okay, so a court must hear the application and dismiss the application, and the grounds for dismissal must be that the application is malicious, deliberately false, frivolous or vexatious. Okay, so if any of those elements are not met, then the court has no power to award costs at all, such as where the application is withdrawn or dismissed without hearing. So when you hear ECW and BAK, what I'm saying is that if you're working with people through this legal process, and you know and you can see that an aggrieved and cross respondent as one party, you can see that their application has a lot of merit, but the application against them doesn't, just because that application has no evidence and it's not supported by anything, it's inconsistent, doesn't mean that cross application has any less merit in the sense of having to run through to the final stage of a proceeding, but it comes at the risk of costs. And in my view, that the intersection between the ECW and BAK case is actually about reminding everyone and reminding practitioners and reminding magistrates from the district court, saying cost is something that can absolutely be awarded, but if you run a case, you should be allowed to have the opportunity to run your case, but be cautious of running a case that is malicious, deliberately false, frivolous, or vexatious, because there can be very real consequences.
Jason, might be good to take some questions shortly.
Yeah.
We've got 10 minutes.
Yeah. I will briefly touch on this one point. Okay, because this is part of the Counselling Notes Protect Service. There are changes in 2017 where the Evidence Act, the Domestic and Family Violence Act, and the Criminal Code were amended to create a legal protection or privilege over counselling records of victims or alleged victims of sexual assault offences in criminal, domestic violence, and some civil law proceedings. There is a service which we run as a collaborative effort with Women's Legal Service. If your client is a victim or victim survivor of sexual assault offences, and it's in part of an intimate personal relationship, and a subpoena is issued to any counselling record or counselling service provider, you should absolutely be making sure that your client has some independent advice about their rights relating to the protection of their counselling notes with respect to sexual assault offences. There's some information on the slides about what the service provides and who it provides to. It's not just parties, it's also to sexual assault counselling services. I would strongly encourage anyone who's interested in this Counselling Notes Protect space to go onto our YouTube channel and to find the CNP webinar, which has been conducted. It's an excellent webinar. I strongly suggest everyone to go and hear about this new legal landscape, which Queensland is actually 20 years behind New South Wales in creating these privileges. So we'll jump onto some questions now.
And then we can come back to
come back to practical hints and tips if we've got time.
Great,
I'll just go previous.
And also noting the fantastic tips and practice points that you've included throughout the presentation. So we'll just have a look at some questions now.
Technology.
Okay, actually, we haven't. Are there any questions? I was thinking we were running out of time to address questions, but it looks like there's not too many there. So if we go back, Jason, to our practical hints and tips, if anyone does have a question, this is the time to submit those questions and we can address them.
Practical hints and tips, and this I think is important whether you be assisting them as a social worker or assisting them as that first initial legal advice. Always encourage your client to get legal advice or a secondary legal advice before they submit or complete a legal document. Go back and look at the elements of domestic violence in this template, all the legislation, choose your poison, and use those headings that we talked about: physical acts of domestic violence, sexual abuse, emotional abuse, economic abuse. It gives the headings that the court requires so that they can lead a decision from the material on the first court occasion. Always fearlessly and confidently tell the court about your client's cultural and linguistic diversity. Tell the court about their hearing impairment. For those people who do work with the LGBTIQA community, this is a really practical tip that's coming up more and more and more is that in where parties to the proceedings are trans, sometimes an aggrieved person refers to a respondent in their dead name. That's actually an act of domestic violence in itself, because that's bringing a person's dead name back into proceedings, and then they have to explain themselves and out themselves through the entire court process, and it's quite horrific. So be very conscious of, if you are dealing with someone who identifies as trans and they're living as their true selves, don't be afraid to write to the court on behalf of your client and correct the court record. We have to do this fearlessly for our clients who are vulnerable, whether they can't speak English or have a limited understanding, or whether they have some kind of impairment, or alternatively in the LGBTIQA space, where issues of name and gender identity can be used as emotional violence against someone else. Always consider using the online forms. There are some great forms on the court's website, and download those templates. Always consider helping the aggrieved apply for legal aid and assist with their completing their application paperwork. Sometimes it's about just reading the question a second time, because it's a bit overwhelming for people to look at their legal aid application, and partnering with them to make the phone call to legal aid to get some telephone legal advice. We do run a telephone clinic with the Violence Prevention and Women's Advocacy team here at Legal Aid. I'm scheduled on Monday, in fact, so we all do it. Our entire team is committed to manning that telephone line to give people prompt and appropriate advice on a short-term basis. It's not long-term, but it's information, and it's valuable information for aggrieveds to have. If your organisation does not have a referral pathway with Legal Aid Queensland, please touch base with us. We'd love to hear from you. The more people who are engaged with our services, the better services that we can provide, and the better outcomes that we can provide to our community. Always check if your area has a duty lawyer service or specialist domestic violence court. In the southeast Queensland, I did see that there were about 50% of people who were from southeast Queensland. There is an enhanced model of dedicated duty lawyers going around, so places like Redcliffe, Sandgate, Brisbane all have a dedicated model, so everyone has an opportunity to have legal advice and legal representation, so far as they are listening to the legal advice that we give them. And then you've got the specialist models of Southport and Beenleigh. So there is a lot in the immediate southeast corner. Toowoomba, there are DV duty lawyers. There are duty lawyers at Caboolture, Maroochydore, Rockhampton, Mackay, and then of course the specialist model in Townsville. And I do know for a fact that there are duty lawyers every DV day in Cairns and Mount Isa as well. So there are duty lawyers. Don't be afraid to refer your clients to speak to them. That's a bit of a quick resource form. That's a video. It does feature me, which I got roped into, and that's the Brisbane court. It can actually be quite a good video to show to your clients. It is translated into other languages as well. So that might be for anyone who has called clients to go and give that resource to them. Now, I will just briefly say we are talking about gendered violence and LGBTI, and when we talk about the LGBTIQ community, the statistics that are coming through are indicating that same-sex attracted men experience sexual and emotional violence from their intimate partners at the same rate, or close to the same rate, as heterosexual women. Same-sex attracted women experience at a rate slightly higher again. And then when we're talking about trans people who identify as trans, they're living at the highest rate of sexual and emotional abuse from their intimate partners. So it's something that, while we do talk about the gendered nature of violence, that we do talk about gender and power dynamics and how it impacts on diverse relationships. So it's important to consider that, particularly as we are talking about gender-based violence today. And gender is a key conversation in the LGBTIQ community.
We'll get help. I think you've covered off a lot of there.
So here we all are: Brisbane, Bundaberg, Caboolture, Cairns, Inala, Ipswich, Mackay, Maroochydore, Mount Isa, Rockhampton, Southport, Toowoomba, Townsville, Woodridge. There are also other services which we partner with, and we have robust conversations with people like Women's Legal Service, your local community legal centres, whether that be the Rockhampton Community Legal Centre or Bayside Community Legal Centre. There are plenty of places which can link you into legal aid. Please don't be afraid to reach out, and that's our contact details.
Great, and that's exactly 11 o'clock. So for anyone that does have any questions that come up that you'd like to address to Jason, we can, if you send those to webinars@legalaid.qld.gov.au, and we can address those. We had a few questions that came in before the webinar through the registration process, and we've covered those. Jason's covered those throughout the presentation, so I hope that you've got that response through that. And I'll just see, yep, there's our question box. Just a reminder also, as we've talked about, all our webinars and legal information are on our YouTube channel and on our website, and you can order any of our publications and resources. And if there are any other topics that you'd like to hear from us for our future planning for our webinars, or indeed if you'd like us to come out to do a community talk to your organisation, we can organise that face-to-face or in the regions, but we do find this is a good way to reach a huge number of people across Queensland. So I'd like to thank Jason for that very informative webinar, and very complex topic, very important topic, very timely in terms of the 16 days of activism, and that support to continue to do the work that you all do as advocates, and acknowledging that work, and the way that you've made it useful for community workers and legal practitioners as well. And it does take all of us in the whole legal and community space to be doing this work and advocating for our clients. So thank you, Jason, and thank you everyone for joining us. And please fill in our feedback survey. When you close the webinar, a feedback survey should pop up. We'd really appreciate your feedback on today's webinar. And thank you very much again for joining us. So thank you, Jason.
Thank you.
Thanks everyone. Bye-bye.